Something extraordinary is unfolding inside a federal courtroom in Miami, and it is not just another lawsuit with Donald Trump's name on the caption. At the center of it is a claim for $10 billion against the Internal Revenue Service, a claim that now appears to be colliding with a far more dangerous question. Was this ever a real legal fight at all? Or was it a staged case designed to open the door to a massive transfer of public money? That is the part that matters, not the headline version, not the political spin. The real issue is whether a sitting president is trying to use a lawsuit against his own controlled agency as the legal cover for a settlement that would never survive ordinary constitutional scrutiny. The allegation is straightforward, even if the mechanics are not. Trump filed a lawsuit tied to the leaking of tax return information, and according to the reporting and legal analysis surrounding the case, the theory was always bigger than the complaint itself. The lawsuit could become the excuse for a negotiated settlement, and the settlement could become the excuse for redirecting money out of the Treasury. Read that again. A president sues an agency he controls, then attempts to settle that lawsuit before a federal judge decides whether the case is even valid. If that sounds less like adversarial litigation and more like Trump versus Trump, that is because the court appears to be asking the same question. Last week, the warning signs were already visible. The concern was that Trump would try to keep the $10 billion case alive just long enough to manufacture leverage, then use the existence of the case itself to justify some form of financial exchange. Without that lawsuit, the transfer would look exactly like what critics say it is, an attempted raid on public funds. Now the situation has accelerated. New reporting indicates that Trump is moving to settle before Judge Williams can decide whether the lawsuit belongs in federal court at all. That timing is not a detail. It may be the whole story. Here is the fast version of the legal problem. Federal courts are designed to resolve real disputes between adverse parties. But when the plaintiff and the defendant are effectively under the same chain of command, the court has to ask whether there is any genuine adversity in the case. That is where the phrase collusive lawsuit enters the picture. In plain terms, a collusive lawsuit is one in which the supposed parties are not actually fighting each other in any meaningful legal sense. Instead, they are cooperating to obtain a court-backed result they could not openly justify on their own. Judge Williams appears to have recognized that danger early. She reportedly signaled concern that the court may not have jurisdiction because the dispute might not be truly adversarial. In other words, if Trump is suing an agency he dominates and controls, there may be no legitimate controversy for a federal court to resolve. That concern was serious enough that the judge asked for briefing from the Department of Justice, the Internal Revenue Service, and Trump himself. She set a deadline of the 20th of May and asked them to address the core issue directly. Is this an adversarial case, or is it something else entirely? That is not a procedural footnote. That is the court asking whether it is being used. Then came the move that changed the temperature in the room. Judge Williams also directed 3 highly respected legal figures to prepare an amicus brief, a friend of the court's submission, designed to assist the court with an independent analysis. Those names matter. Former federal judge John Gleeson, former Solicitor General Don Verrilli, and veteran trial lawyer Faith Gay. That brief arrived within the last 24 hours, And while it reportedly stopped short of flatly declaring the case a bad faith filing, it appears to have done something almost as significant. It gave the judge the legal framework to conclude that there is no proper case here. And once that framework was in place, the scramble began. According to the latest reporting, there is now a rush to settle the matter before Judge Williams can issue a ruling on validity or jurisdiction. That tells you something. Parties confident in the strength of their lawsuit usually want the court to confirm it. Parties racing to settle before the ruling often fear what the ruling will say. This is where the story stops being only about courtroom tactics and becomes a constitutional warning. Trump is reportedly proposing to exchange his $10 billion claim for a $1.7 billion victim compensation fund. On paper, that may sound like compromise. In practice, the question is who controls the fund, who receives the money, and by what lawful authority it exists. The answer, according to the criticism now building around the case, is the most alarming part. The compensation fund would allegedly be administered by a commission of Trump's own choosing, under his influence or control, with public money that would otherwise belong to the United States Treasury. That means collected federal revenue could be diverted away from the Treasury and into a politically controlled distribution mechanism. This is not just about one settlement. It is about whether the executive branch can create its own pipeline from public revenue to a discretionary payout system. If that principle holds, the lawsuit becomes only the shell. The real operation is the transfer. Supporters will say Trump himself is not taking the money personally. That is the fairness pause, and it needs to be addressed. Even if he claims he will not receive funds directly, that does not resolve the legal problem, and it certainly does not erase the conflict concerns tied to family members, businesses, political allies, or affiliated entities. The transcript surrounding this controversy points to another explosive detail. Trump has reportedly framed the proposed fund as a form of compensation tied to what he describes as the weaponization of government under the prior administration. That rhetorical move tries to turn a legally suspect settlement into a moral act of restitution. But rhetoric is not jurisdiction. Political language is not appropriations authority. And grievance is not a substitute for constitutional power. Only Congress controls the purse. That is the foundational rule. Article 1 gives the legislative branch authority over appropriations, and presidents do not get to create off-book compensation systems simply because they believe a constituency deserves payment. That is why legal challenges appear all but inevitable. If the settlement is formally announced, the likely claims are already visible. Plaintiffs would almost certainly argue that the scheme violates the separation of powers, exceeds the powers assigned to the presidency, and attempts to do through executive design what can only lawfully be done by will. Congressional authorization. There's also the Administrative Procedure Act. Any large-scale distribution framework run by the executive branch has to comply with lawful process, administrative structure, and reviewable standards. A politically tailored commission with vague criteria and unilateral control would invite immediate attack under federal administrative law. Then there is the ultra-vires argument, which may become central. Ultra-vires simply means action taken beyond legal authority. If the presidency has no enumerated power to establish this kind of fund and direct the disbursement of Treasury-linked money outside congressional control, then the entire project can be challenged as unlawful from the start. Put those pieces together. First, a lawsuit that may not be real in the constitutional sense, then a settlement rushed forward before the judge can rule, then a public money distribution system built on executive control rather than legislative authorization. That is why this story is moving from legal controversy to institutional alarm. And there is another layer. If the underlying case is jurisdictionally defective, then the settlement itself may be infected by that defect. A court cannot bless a bargain that rests on a claim it had no power to hear in the first place. That is the hidden danger for everyone involved. If there is no valid case, there may be no lawful consideration to exchange in settlement. The whole structure starts to look less like dispute resolution and more like an attempted laundering of public money through the language of litigation. The transcript uses harsh language to describe that possibility. And while the rhetoric is intense, the underlying legal fear is real. If an invalid case is used as the vehicle for transferring $1.7 billion into a controlled compensation mechanism, the issue is not optics. The issue is whether the machinery of the federal judiciary is being invoked to cloak an unauthorized financial act. This is also why the amicus brief matters so much. Independent legal voices do not decide the case, but they can isolate the doctrinal pressure points with unusual clarity. If the brief laid out a path for the court to find no true adversity, no jurisdiction, or no justiciable controversy, then the incentive to settle immediately becomes obvious. A rushed settlement, however, may not end Judge Williams's role. Federal judges do not usually welcome being turned into props for a strategic performance. If the court believes the litigation process was used to create the appearance of legality for a transaction the parties intended all along, that could trigger a very different response. Do not assume dismissal means disappearance. Judges retain tools to examine conduct before the court, including the representations made in pleadings and the behavior of counsel who signed them. If there is concern that the court was drawn into a non-adversarial proceeding under false pretenses, that concern does not automatically vanish because the parties suddenly announce peace. That is why attention is now shifting to what Judge Williams does next. One possible step is the status conference as soon as any settlement is filed. Another is a closer inquiry into whether the lawyers and agencies involved presented a genuine controversy or merely simulated one. That inquiry could become deeply uncomfortable for the government attorneys who participated. It could also reach the Internal Revenue Service officials whose names and positions are tied to the case. When a federal court starts asking whether it was used to facilitate a prearranged result, the spotlight moves from the headline actor to everyone who helped build the stage. There is a broader institutional cost here, too. Every branch of government depends, at some level, on the assumption that legal process is being used for legal ends. Once lawsuits become vehicles for engineered settlements between aligned actors, the line between adjudication and political theater starts to collapse. The controversy also lands at a moment when public confidence in legal institutions is already fragile. That makes the court's response even more consequential. If the judiciary signals that adversarial standards still mean something, that matters far beyond this case. If not, the precedent could invite repetition. Now, to be fair, defenders of the proposed settlement will likely argue that presidents routinely direct executive priorities, that leaked tax information can create real harm, and that some form of compensation mechanism is not, well, automatically improper. That is the strongest version of the other side's case, and it deserves to be heard. But even under that more charitable framing, the same problem remains. A president cannot manufacture legal adversity where none exists, and a president cannot substitute executive preference for congressional appropriation simply by attaching the plan to a courtroom caption. This is where outside litigation becomes almost certain. Public interest groups, civil liberties organizations, state attorneys general, and constitutional litigators are all obvious candidates to challenge the fund. The moment the settlement terms are made concrete, the race to the courthouse may begin. Those lawsuits would likely ask for emergency relief. Plaintiffs could seek temporary restraining orders, preliminary injunctions, and declaratory judgments aimed at freezing any transfer before money starts moving. Once public funds are dispersed through a politically designed commission, clawing them back becomes vastly harder. So the next phase may unfold on two tracks at once. In Miami, Judge Williams may decide whether the original case was legitimate or collusive. Elsewhere, new plaintiffs may attack the settlement itself as unconstitutional, unauthorized, and void. That dual-track pressure is important because it means settling the case may not solve the underlying problem, it may actually widen it. A jurisdictional cloud over the original suit, combined with constitutional litigation against the settlement, could tie the entire compensation scheme up for months, if not longer. There is also the political symbolism of the reported reduction from $10 billion to $1.7 billion. Supporters may call that moderation. Critics will call it something else, folding on the amount while preserving the mechanism. And the mechanism is the real story, not whether the number is 10 billion or 1.7 billion, not whether the fund is described as relief, compensation, or justice. The central question is who has lawful authority to create it, control it, and direct where the money goes. The transcript warning is blunt. If this proceeds, it will spawn immediate legal backlash. That prediction is hard to dismiss. The constitutional objections are too obvious, the institutional stakes are too high, and the factual posture is too unusual for this to pass quietly. There is one more point worth underlining. A federal judge concern about adversity is not a technicality cooked up by specialists to slow down action. It is one of the guardrails that prevents the courts from becoming instruments of executive design. If that guardrail fails here, the consequences will reach beyond tax records, beyond settlement language, and beyond one administration. What happens next may depend on timing measured in days, not months. If the settlement is announced before the court rules, the legal and political fight will intensify immediately. If Judge Williams acts before the settlement is finalized, the entire strategy could be thrown into doubt. Either way, the illusion of a routine dispute is gone. This is no longer just a complaint over leaked tax information. It is a test of whether the executive branch can sue itself, settle with itself, and then redirect public money under the banner of legal resolution. That is why so many eyes are now on Judge Williams, the amicus brief, and the next filing. This is not simply about Trump's claim. It is about whether the judiciary allows itself to become the entry point for a transaction Congress never approved. And that is the closing fact that cannot be softened. If there is no real case, there can be no legitimate settlement. If there is no lawful appropriation, there can be no lawful fund. And if both are missing at the same time, then what comes next will not be remembered as ordinary litigation. It will be remembered as a direct test of whether constitutional limits still hold when power tries to outrun the law.